Let's try to stay on time and begin. Osio, and good morning to all. We're so pleased that you have joined us for our conference on implementing the UN Declaration on the Rights of Indigenous Peoples in the United States. I'm Kristen Carpenter, Director of the American Indian Law Program here at the University of Colorado. And together with my friend and colleague, Heather Whiteman-Runsham at the Native American Rights Fund, I've had the pleasure of organizing this event under the guidance of our bosses, Jim and I and John Echohawk, who will soon give a more formal welcome. At this point, I just wanted to say, and I think she's stepped out, most importantly, to thank Ejael Casaperalta, who has done really all of the work, substantive, visionary, and logistic, to bring us all together. Ejael, are you right there? We're thanking you for your... Ejael is a graduate of our law school from 2018 and just a brilliant woman, a terrific lawyer and community organizer herself, and a great colleague. I'm grateful to her and to so many people who brought us all together today. Thank you also to Wei-Joan Udden, who's done a lot of the work, John Cibre and the IT staff who are doing all of the technology and making this event available on live stream. We'll send out the link so that you can share it with colleagues who can also watch along. Julianne Williams, Heather Martin, the library staff. There's a special exhibit upstairs in honor of this event with many of your scholarly works on display if you'd like to see it, as well as the Native American Law Students Association who have come out to volunteer, many of my students who are here in the room. I'd also like to acknowledge our colleagues across campus at the Center for Native American and Indigenous Studies who have supported this event. They're speaking, and Renata Birchfield has helped us with the logistics. Our fourth co-sponsor was the International Year of Indigenous Languages under the auspices of UNESCO, and we're grateful to have their support as well. And thank you to all of you who braved the snow and the wind and the so-called bomb cyclone to be here. We're really, really glad that you made it. Perhaps more so than our other conferences here at the law school, this one is really offered in the spirit of a movement, or next steps in a movement started generations ago by the struggle for tribal sovereignty here in the United States and the struggle for human rights internationally. We now bring these strands together with you, hoping to inspire action for the well-being of Indigenous people in the US for social justice and beyond. It's a collective effort, and we're so glad that you're here with us today. I will pass the mic to my dean, Jim Anaya, to give some opening remarks. Thank you.
I always like coming through those curtains. Welcome, everybody. It's great to see everybody here at the University of Colorado Law School. And thanks for braving, as Kristen said, the snow, the wind, and all the elements to come here. Those of you who had to, we're really pleased that you made that extra effort. This conference is part of a larger project that the law school is sponsoring in partnership with the Native American Rights Fund. And I want to thank John Echohawk, from whom you'll hear in a moment, for his leadership in this initiative to advance the implementation of the Declaration on the Rights of Indigenous Peoples in the United States, and of course, acknowledge John's leadership in advancing the Native rights movement in the United States and really around the world for decades. So special acknowledgement and welcome to John. You'll hear from him in a moment. And on behalf of the law school, I'd like to again thank all of you for coming, especially our speakers and those of you who had to travel significant distances to be with us the next couple of days. We deeply appreciate your participation and what each of you will bring to the conversation about this important topic for Native peoples in this country. As you can see from our agenda, we have a very full and exciting program. We're all indebted to Kristen Carpenter for pulling this all together along with Ejael. So please join me in thanking Kristen for her initiative in this regard. I should mention that Heather Whiteman-Runsham, also from NARF, was instrumental in organizing the event. So I don't know if Heather is in, but thanks to Heather, and if she's not, she'll be here in a moment, or maybe she's in the hall drinking coffee. I'd like to take a moment to just say a few words about the UN Declaration on the Rights of Indigenous Peoples and the purpose of this conference. The picture you see here was taken at the precise moment of the vote on the Declaration on the Rights of Indigenous Peoples. I think you can see the back of Daley's head right there. And there were perhaps others of you in the room at the UN General Assembly when this vote was taken. And at this moment, the aspiration to have a declaration on the rights of Indigenous peoples was turned into reality. It really was quite a dramatic moment. And we see the declaration and an affirmation of the rights of Indigenous peoples officially becoming part of the architecture of the global system for the protection of human rights. You can see the vote tally on the board with a listing of countries from across the globe who voted on the declaration. The vote was 143 in favor, 11 abstentions, and 4 against. Let's see if anybody can guess which those 4 were, among whom the 4 were. So the United States, was among them. Those casting negative votes along with Australia, Canada, and New Zealand. Eventually, however, each of these countries reversed positions in statements that were in some way qualifying, but that nonetheless provided official alignment with the Declaration's essential terms. Now, the Declaration is by no means a perfect instrument. We'll probably hear about that from some of our speakers and discussants today. And for many, it is a disappointment because it assumes that the place of Indigenous peoples will continue to be within the basic architecture of existing state power. Yet, I think it's fair to say, and I believe firmly, that the Declaration envisions a new arrangement and political ordering that follow the arc of history, sluggish as it may be, toward a more just and humane world. By its explicit term, the Declaration acknowledges and turns its back on the oppression and denial of basic human rights and democratic freedoms that Indigenous peoples have suffered and have continued to suffer in many ways. Premised on this recognition of historical and ongoing inequities, the Declaration motivates conciliation with Indigenous peoples and provides a guide for steps for that conciliation. It does so by broadly affirming the collective and individual human rights of Indigenous peoples, while calling on governments across the globe and international institutions to work cooperatively to see those rights reflected in the everyday lives of Indigenous peoples. The Declaration embodies a convergence of common understanding among governments and Indigenous peoples worldwide upon a foundation of fundamental human rights, including rights of equality, self-determination, property, and cultural integrity. It is a product of more than 2 decades of deliberations in which the experiences and aspirations of Indigenous peoples, along with failures and successes of the relevant laws and policies of governments, were closely examined with a view toward promoting human rights. The Declaration envisions a future in which the countries of the world embrace and uplift Indigenous peoples on fair and equitable terms with effective recognition of their rights to exist as distinct peoples in harmony with the societies that have grown up around them, free from social and economic disparities rooted in histories of mistreatment. But as we know, the vision projected by the Declaration is far from being realized in the lives of Indigenous peoples, including Native peoples in this country. So as we ponder the possibilities of a genuine process of implementation of a new reality for Indigenous peoples, it is obvious that history cannot be undone. But the future can mark a new direction as projected in the Declaration. The terms of the Declaration remain substantially unfulfilled, and this gathering is a reflection of the challenge of fulfillment that still lies ahead. In particular, the purpose of this conference is to help catalyze, resolve, and strategies to see the Declaration implemented in the United States. The goal is to see the Declaration function as an instrument of reform in U.S. law and policy toward Native peoples, such that the Declaration's norms will increasingly be reflected in, rather than be in tension with U.S. law and policy. It's a great honor for the University of Colorado Law School to co-host this event with the Native American Rights Fund. Having this event at Colorado Law allows us to advance our mission to educate, to be a platform for the development and dissemination of knowledge, to challenge the status quo, and to have a positive impact on society. This event is also notable. It's also a notable example of our dedication specifically to address issues concerning Indigenous peoples, including through our American Indian Law program, which is the driver for this event. We're pleased to have with us guests from across the country and some from other parts of the world. Again, welcome. It's a thrill to have you all with us, and I wish you all a productive time with us. Thank you.
Good morning. I'm John Eckelhawk, Executive Director of the Native American Rights Fund, and we're really pleased to be able to co-sponsor this conference with University of Colorado Law School. When Dean Anaya came here a couple of years ago as the new dean, we were very elated over at the Native American Rights Fund because, as you know, the dean for many years was the special rapporteur on Indigenous rights at the United Nations, and basically an expert on the Declaration and these international laws impacting Indigenous peoples. And we have worked on those issues at the Native American Rights Fund for many years. I think, as many of you know, we're the National Indian Legal Defense Fund with the central office here located in Boulder, Colorado, and we've been here doing this work for 49 years, providing legal assistance and advice to tribes and organizations, individuals across the country on these major issues where they don't have counsel. And unfortunately, that's a lot of our people, so that's involved us in most of these major cases around the country over this time period. The work that we have done, I think, has really led the way in terms of getting this government to recognize the rights of Indigenous peoples, primarily through fulfillment of the treaty obligations this country has. We were generally successful leading a litigation revolution that began in the 70s. A lot of these cases ended up in the U.S. Supreme Court, cases we worked on. Other advocates got their cases up there as tribes started to realize the importance of this legal advocacy work. Most of those cases we were victorious in, and it really kind of changed Indian country and changed this country as a whole. But beginning in the 90s, about the third decade of this litigation, we started realizing that we were starting to lose more cases than we were winning in the U.S. Supreme Court with the change in the makeup of that court. And we started discussions of the staff and the board at the Native American Rights Fund about what we could do about that, because we'd basically been living based on the litigation. And so what do we do with this litigation strategy that we've been employing with the changes in the court? And one of the things we came up with was to try to do something in international law that would support what we're doing here domestically. And of course, for decades, the discussions about the Declaration have been going on in Geneva. So in 1999, we undertook representation of the National Congress of American Indians, the large national intertribal organization, representing the tribes there in Geneva on the Declaration. We started that work in 99, and of course 2007, as Dean and I pointed out, the declaration was adopted by the United Nations, and then eventually in 2010, supported by the United States government, and that support that came from President Obama, I think, was largely due to the advocacy done by the National Congress of American Indians, our client. We worked very hard to get this country to finally sign on to the declaration. Since 2010, of course, we've tried to do what we could to implement it together with working with everybody across the country on that, because in the declaration, when you look at it, even though, as the Dean said, it's not a perfect document, it has language in there that basically supports everything we're trying to do in our advocacy work, in the courts, in the Congress, in the administration with the agencies. There's something in the declaration that supports everything we're trying to do. So we need to ramp up that effort and utilize the declaration more in support of our advocacy work. And of course, that's the main purpose that we're here for at this conference, is to see if we can't refine those strategies and find better ways to use the declaration to make a difference in all of our advocacy work. We're really pleased to, like I said, have the participation of the University of Colorado Law School, headed up by Dean and I, and the great faculty they have here, Kristen and others, who work on this issue together with us. And now with you all here, we can all put our heads together and see if we can't find a way to utilize the declaration in a better way to improve the lives of all of our Native American people. So thank you for being here, and let's begin. Kristen?
Hi, and welcome to all of you who've been coming in. We have a standing room only crowd expected, so I'm glad you all are starting to make it, given the weather and everything. So we'll begin with our first panel. Heather Whiteman-Runsum from the Native American Rights Fund will be moderating, and we'll have our address by Walter Echo Hawk, participating by phone, given the weather situation, and an all-star panel of respondents. So if that panel would come up to the front, we can go ahead with that. Thank you. Here's Walter Echo Hawk on the screen, though sadly not with us in person. And I'm going to let the tech people figure out the next steps here. Thank you. And Heather, I was giving you props earlier as my co-organizer and partner in crime. So here she is in person to run the panel, and I'll let you take it from here. Thank you.
Okay, good morning, everyone, and thank you all for being here on a week when I think we've all had our challenges in getting to where we needed to be for several days now. I'm glad to see everyone out there, and it's really my extreme pleasure to introduce this panel of speakers and our address from Walter Echo Hawk. It almost isn't necessary to introduce Walter to the folks here in the room. I think we all know a lot about Walter and his work, and just have tremendous regard for everything he's done and continues to do. But I'll go ahead and do the perfunctory introduction anyhow, and then we'll get going and let him take over. Walter Echo Hawk is a Native American attorney, tribal judge, author, and law professor who represents Indian tribes on important legal issues such as treaty rights, water rights, religious freedom, prisoner rights, and repatriation issues. His career spans the pivotal years when Indian tribes reclaimed their land, rebuilt sovereignty, and pride in a stride toward freedom. He was a staff attorney at the Native American Rights Fund for more than 35 years, and he was instrumental in securing the passage of 2 federal laws that respect Indian and religious freedoms and the repatriation of Native American remains. Mr. Echo Hawk is a member of the Pawnee Nation, and he received a political science degree from Oklahoma State University in 1970, and his law degree from the University of New Mexico in 1973. He is the author of In the Courts of the Conqueror, the 10 Worst Indian Law Cases Ever Decided in 2010, and more recently, In the Light of Justice in 2013. Both of these books have been, I think, real guiding foundational pieces of work that we've looked at and learned from and benefited tremendously from as we're bringing this project with CU Law into being. So, Walter, I believe you're out there somewhere. Do I need to do anything? Cue up the audio? Okay, we're getting it set. We have a really great picture of Walter that we put up on the screen for everybody since we weren't going to benefit from his physical presence. If any of you out there have other pictures, we could probably put a slideshow together really quickly while he's talking. Just keep everybody awake. But while we're waiting, I can go ahead and introduce our other panelists who will be providing additional thoughts to Walter's presentation. We are very lucky to have with us today Ms. Daly Sanladuro. Oh, we'll continue that soon.
Okay. Yes, thank you, Heather, for the introduction, and very glad to be here, everyone. Good morning. I commend everyone for being there. I think you are very hardy souls to have braved the big storm, and I wish I could be there in person with you. I am coming to you from my home here in rural Oklahoma. I got caught flat-footed yesterday when all of our flights to Colorado were canceled yesterday due to the storm, and again today. And so in any event, I am very honored to be here and to serve with the distinguished panelists that are with me this morning. My remarks will touch on 4 areas. First, why are we here? Number 2, I wanted to provide some of my thoughts for the need for reforming federal Indian law and strengthening it with the UN Declaration standards. Third, I'd like to take a look at the path ahead briefly, and that is the short-term path ahead during the Trump era. And then finally, I'd like to share my thoughts on what we can do now in the short term during the Trump era, which I view as a very critical research and planning stage for our campaign to implement the Declaration. First, why are we here? We are gathered here, or you are gathered there, I should say, at this kickoff conference for an important purpose. And that is to address at the inception conceptual and strategic aspects for implementing the Declaration into U.S. law and policy. The Declaration has a great purpose, and that is to restore the inherent indigenous and human rights to indigenous peoples and to provide them with restorative justice. And there can be no higher goal than the pursuit of justice. And we cannot rest until that goal is obtained. And our starting place, it seems to me, in our campaign for bringing restorative justice for First Americans is to make our well-laid plans and strategies to fulfill the principles outlined in the Declaration, to domesticate them and incorporate them into federal Indian law. So I'm glad we're here today, and I'm very thankful to NARF and to CU Law for forming this vitally important national project to implement the Declaration. You know, since 2007, when the UN approved the Declaration, we here in the United States have been looking for lawyers of a certain kind to help lead us into the human rights realm. And now we've found them here in Boulder, in this very room. And I just want to remind everyone that today is a historic time. We do sit at the confluence of international law and domestic law, thanks to the makers who made the Declaration. And as Professors Carpenter and Riley have said, this is a jurisgenerative lawmaking moment in our legal and social history. And I think we can see that we do have great opportunities and challenges that lay in the path ahead. So I think it's incumbent upon all of us to take courage, to be cocky do in my language, Pawnee language, to be without fear. And we need to, I think, become social engineers at this point to make our domestic legal system better for Native people. I think we need to use strategic law development methods like our forebears in all of the great American social justice movements used in years past. I believe we need to raise our vision above the daily press of our legal affairs to see the big picture, because we're not going to get to the promised land by using business as usual attitudes. And so I'm very glad that this conference has been convened to prepare our plans for our campaign for a march to Indigenous justice here in the United States. And I have no doubt that the Great Spirit's going to be at our side to help us find ways to inject the human rights principles into federal Indian law to make a stronger, more just legal framework for defining and protecting Native American rights here in the United States. And I do believe that the need for law reform is self-evident. Everyone is well aware that our legal framework, federal Indian law, arose from the law of colonialism. Scholars have traced the roots of this legal framework all the way back to medieval Europe, and their scholarship leaves no question about the need for reform, because we all agree that federal Indian law's got a dark side to it. It contains unjust case law that rivals Plessy v. Ferguson in manifest injustice. And many scholars have identified the defects of our existing legal framework, but very few have laid out a path to reform those defects. And that task, I believe, falls to us. And we can see as we look around Indian country today the end products of our dark side of federal Indian law that are still seen today. There are not 7 areas I just want to draw your attention to. Number 1, Congress can curtail self-determination and self-government at will. under the plenary power doctrine. Number two, the Supreme Court can trim tribal sovereignty at will through its doctrines of implicit divestiture of tribal sovereignty. Number three, equality and non-discrimination in the law are beyond reach so long as judicial notions of race, conquest, and colonialism flourish in federal Indian law. Number four, tribal communities are the most violent places in the country, yet the Supreme Court rules that tribes have no jurisdiction over non-Indian crimes. Number five, tribal culture is under assault due to a failure in the law to protect holy places, intellectual property rights of indigenous peoples, meaningful protections for our language restoration, culturally appropriate education, and indigenous habitat. Number six, hard to solve social ills and deplorable socioeconomic gaps exist in our tribal communities around the country simply because those problems are not seen by federal law as human right problems. Number seven, the political relationship between Indian nations and the United States falls short of the Worcester Protectorate that was originally envisioned by John Marshall, because federal government decision-making falls short of the UN free, prior, and informed consent standards. However, despite these end products, if we can replace the dark side of federal Indian law with the UN standards, we will have a much stronger, more just, and more reliable legal framework. So let's take a look at the path ahead, the short-term outlook. As I see it, there is a lot of work that lays ahead. We got to be smarter than ever before. However, I think we can take heart in looking at other social justice movements and know that Indian country is much better situated in the year 2019 for our march to justice than, say, Black America was when NAACP was formed in 1910 to begin its march to equality under the law from Plessy v. Ferguson. Yet in that 8-year period, they were able to overcome all of their hurdles. And today, we have more than 2,000 Indian attorneys. We got law professors throughout the law schools around the country with vibrant scholarship. We have nearly 100 Native American studies programs. We have much experience from the tribal sovereignty movement from 1970 to the present. We have in the UN Declaration a foundational document in place. We have UN Special Rapporteur James Naya's report, 2012 report, the situation of indigenous peoples in the United States, which shows us recommendations for starting our campaign. And we know that from a legal standpoint, the norms that are found in the Declaration are automatically part of the federal common law, international norms from customary international law. So we have a starting place for test cases as well. But in the short term, we do need to be aware because we do live in dangerous political times now in the Trump era. We see our society is deeply divided, marked by rising hate speech, hate crimes, fear-mongering, overt racism, and our civil discourse has devolved into name-calling. Our political institutions are highly polarized by extreme partisan politics, which sees political rivals as enemies, traitors, criminals. And our central government is unstable at this time, marked by gridlock, shutdowns, partisan strife, manufactured national emergencies, attacks on the free press, and we have an elected president with no government experience with totalitarian or authoritarian tendencies. And we can see that since the 1990s, our democratic norms have been weakened and are under assault. So a lot of our political scientists see these elements as indicating a gradual slide towards authoritarianism. And this troubled time does present a supreme test of our system of checks and balances. And many political scientists wonder, is this how democracies collapse from within? Certainly for tribal leaders, these are testing times in the Trump era as they weather the storm and navigate these troubled waters. Yet even in this troubling short-term environment, there's always a silver lining in every dark cloud. And I think while we waited out until our democracy rights its ship, there's much work to be done by this our national project because this period furnishes us with a much needed research and planning time for us to lay our plans, to develop our strategies, to build the infrastructure for our campaign, to lay a scholarly foundation for our cause, to prepare ourselves for a national discourse on human rights for Native Americans, and also to pick some low-hanging fruit. This is foundational work that we need to do at the outset, and we're given this opportunity to do it so that we can be poised and ready to ride on the very first wave on the rebound when that door opens. And so I do think we have two important axioms here. The first is that well-laid plans allows a smaller force to overcome a much larger foe. And secondly, the general makes many calculations in his temple ere the battle begins. And so let us make good use of this valuable time to make our plans during the short-term outlook, while we do have an opportunity to build a solid foundation for our campaign so we can be ready to take the proactive steps when the timing's right and the stars are perfectly aligned, and so that we can avoid any missteps in the minefields ahead. But there's much we can do and should do now to build a solid foundation for our campaign, and I just want to conclude by sharing my thoughts on what can be done now by our national project. The first, I think, is to make a litigation plan for test cases, just like the NAACP Defense Fund had to do at the outset when it made its Margold plan to take Black America from Plessy to Brown. They needed a litigation plan. Secondly, we need to get funding and infrastructure for our campaign. Thirdly, I would suggest that we need to enlist preeminent scholars from the fields of law, Native American studies, and other disciplines to research, write, and vet 9 definitive white papers that analyzes the 9 core areas or 9 core themes of the Declaration, that being the self-determination and indigenous institutions, the equality and non-discrimination principle. 3 would be survival rights. 4 would be a white paper on cultural rights. 1 on education and public media. A white paper on political participation, decision making. A paper on economic and social rights. A paper on land, territories, and resources, and a paper on treaties and agreements. These white papers should cover 4 areas: to do a comparative legal and policy analysis between international law and federal Indian law, to identify gaps and to target gaps for our campaign between our existing domestic legal framework and the UN standards. Secondly, the papers need to identify goals for closing those gaps, both short-term and long-term. Third, the papers should identify a working group for that particular subject area to be picked from Indian country and civil society. And then fourth, to develop a national plan of action to achieve those goals. And I think that well-vetted white papers of this nature could serve as a solid foundation for our campaign. And along the way, our scholars would become, I would hope, thinkers on the order of find the laureates for this current generation, visionaries such as Mahatma Gandhi, Martin Luther King, and our Chief Josephs, and our social engineers that are conversant in strategic law development, such as Thurgood Marshall. Second, the next area of work that I could think of would be human rights education. For our attorneys, the national project could conduct CLEs and seminars and training to teach lawyers how to litigate test cases to incorporate international human rights and indigenous rights from the Declaration into our law. How do you prove that a UN standard in the Declaration is a norm in customary international law? That's a fact test that needs to be litigated for it to become part of our federal common law. For the public, we need scholarship and education to teach the public why the Declaration is needed. For Indian country, we need human rights education to mobilize our people and educate them so that human rights precepts is upon our lips, and the same for our allies. Fourth, the next area of work that could be done during this period is to compile a body of scholarly literature on human rights for Native Americans, law review articles, and books and other publications, which could serve as the underpinning for a social movement. And then lastly, I could see activity that would go after low-hanging fruit by way of bringing well-calculated test cases and to seek legislation on the grassroots level from each and every Indian nation to incorporate and adopt and advocate for the Declaration. State laws that could be passed from Hawaii to Maine doing the same thing, all in the area of low-hanging fruit. And I think along the way we can gain our experience to ready ourselves for a national legislation to do the same thing. So in conclusion, I want us all to urge everyone, to let us work to support this national project. If we don't implement the declaration, all of the work that was done in the making of the declaration would be in vain, and certainly that would be intolerable for our generation simply to stand pat on the shoulders of our forebears and try to cope with and live with this dark side of federal Indian law. And so, in conclusion, I think that we should remember the words of Siegfried Wiesner, and his teaching to me is that domestic legal systems are and have always been international law's main engine of enforcement. So let us use our domestic legal system to enforce the declaration, to domesticate the indigenous rights that do come to us from international law into federal Indian law. For as the late David Getches said, we have to pay close attention to the health and well-being of our legal framework, because it's just like the car that we drove up in. And so we need to be sure that all is well for our legal framework for Indigenous people. With that, I want to again thank everyone, to wish you the best. I wish I could be there, but as I mentioned in emails to Kristen, I think Mother Nature blocked my path to Boulder this time. But I do wish each and every one of you well, and thanks for allowing me this time. Thank you.
Okay, thank you, Walter, for those very good and informative and instructive words. I'm going to go ahead and introduce the three panelists now, who I think will ask each in turn to come up and give some thoughts on what Walter has presented, as well as other issues and topics that they feel are relevant when we're talking about incorporating the UN Declaration into federal Indian law and other domestic law in the United States, including tribal law. First, we have Ms. Daly Samboduro. Dr. Daly Samboduro holds a PhD from the University of British Columbia, and she has also a Master of Arts in Law and Diplomacy from the Fletcher School at Tufts University. She is currently the elected international chair of the Inuit Circumpolar Council, which I think is amazing and really wonderful. And she is a senior scholar at the University of Alaska in Anchorage. She is currently an expert member of the United Nations Permanent Forum on Indigenous Issues, the Alaska member of the Inuit Circumpolar Council Advisory Committee on UN Issues, and a member of the International Law Association Committee on Implementation of the UN Declaration on the Rights of Indigenous Peoples. Dr. Duro has a long history of direct involvement in the discussion, debate, and negotiation of the UN Declaration. She was an active participant in this work from 1985 up until the time the Declaration was adopted by the UN General Assembly in 2007. She specializes in public international law, international human rights law, international relations, and Alaska Native self-determination. She has experience in the administration, management, and coordination of statewide, national, and international organizations, as well as estimating and oversight of federal, state, and private construction contracts. Our next panelist is the Honorable Nathaniel Brown. He has graciously stepped in on short notice to fill out the panel when one of our other panelists, Frank Jadwigijic, wasn't able to complete his travel plans to be here with us. I spoke with Frank yesterday, and he really regretted missing out on this gathering, but he's looking forward to continuing this important work with us all. Nathaniel is the delegate to the 24th Navajo Nation Council, and he represents the communities of Kayenta, Chilchimbito, and I probably didn't say that right.
You did.
I did, good. And Untitled chapters. And he's a member of the Health, Education, and Human Services Committee in the Navajo Nation Council, Sexual Assault Prevention Subcommittee, and the Arizona Human Trafficking Council. He also serves as the UN representative for the Navajo Nation. In 2017, he was instrumental in passing a law against human trafficking on the Navajo Nation reservation. And I have to commend Mr. Brown for his dedication to showing the UN and the various bodies there the importance of having tribal government officials as part of their proceedings and contributing to their dialogue. He's been at the UN and put in the time and been patient with those processes and made sure that the Navajo Nation's voice was heard through those. So we wanted to commend him for that and thank him for that. And finally, I could read this biography for the rest of the time we're allotted. Matthew Fletcher is a professor of law at Michigan State University College of Law. He's the director of the Indigenous Law and Policy Center. He sits as Chief Justice of the Porch Band of Creeks Indians Supreme Court and also is an appellate judge for the Grand Traverse Band of Ottawa and Chippewa Indians, Mashpee Wampanoag Tribe, and Machibenashuish Band of Potawatomi Indians, the Pokagon Band of Potawatomi, the Hoopa Valley Tribe, the Nottawasepi Huron Band of Potawatomi Indians, and the Santee Sioux Tribe of Nebraska. He is a member of the Grand Traverse Band located in Peshabstown, Michigan. His record of publication and scholarship is lengthy. He's contributed to the vast array of hornbooks, casebooks, federal Indian law, manuals, and whatnot, as well as some really wonderful law review articles that I think we all have found tremendously helpful in our practice of law. His scholarship has been cited twice by the U.S. Supreme Court in more than a dozen federal, state, and tribal courts, and in dozens of federal, state, and tribal court briefs, and in hundreds of law review articles and other secondary legal authorities. He is the primary editor and author of the leading law blog on American Indian law and policy, Turtle Talk. Professor Fletcher graduated from the University of Michigan Law School and the University of Michigan in 1994. He has worked as a staff attorney for 4 different Indian tribes, including Pasquayaqui, Hoopa Valley, Suquamish, and the Grand Traverse Band. And he is married to Winona Single, who is a member of the Little Traverse Bay Band of Odawa Indians, and they have 2 lovely sons, Owen and Emmett. So what we're going to ask, I think, is for each of the panelists to come up and give some thoughts, and we're hoping that we'll hear from them about their thoughts on how and why it's important to incorporate the provisions of the Declaration into federal Indian law, some ideas about where that may most effectively be done strategically or otherwise, and perhaps a few words on the current cases pending before the U.S. Supreme Court and what their impact could be on the important work that we're embarking on here today. So Daly, would you like to come up first?
Mick, first of all, I'd like to thank Kristen, also Heather, the law school here, Native American Rights Fund, and all those who put in time to organize the gathering. Is it being live streamed as well? Okay, good. So for all those that weren't able to make it here, greetings to you online as well. I just came from Mexico City, Mexico. There was an international workshop on autonomy, self-governance as a dimension of the right of self-determination and a widespread dialogue. And Erica Yamada was present as well from MRIP, and it was one of the more enlightening, but also I think vital conferences that has been held in a long time, and really afforded us the opportunity to more deeply discuss autonomy and self-government as a dimension of self-determination and what's happening at the ground level, at the most practical level, when we talk about the right of self-determination and how it's manifested amongst our people. In order to respond to the invitation and what Heather has asked of me, I would wholeheartedly endorse Walter's suggestion about this cluster of white papers. Is that me or? The clusters of the white papers that he talked about, I think that it would be very useful, very constructive to have some well-researched and deeply considered approaches to some of these areas in our particular legal and political context. He mentioned the continuing legal education. I had that in my notes earlier as well. Though he cited that we have 2,000 Indian lawyers working in this area, we certainly need more. And I know that CU and this law school and elsewhere, that it is a growing trend. And I think that every single program that looks at Indigenous studies or Indian law must in fact incorporate human rights dimension. In fact, entire courses that focus specifically on the emergence of not only the UN Declaration, the American Declaration on the Rights of Indigenous Peoples adopted by the OAS in 2016, as well as the ILO Convention number 169, of which Jim and I were some of the very few Indigenous people engaged in the revision of Convention 107 that resulted in Convention number 169. But also all other international human rights instruments. I think that too often we forget that this entire regime is at our fingertips. So not just the Indigenous specific instruments, but we also need to interpret all the other existing international instruments, especially in the context of Indigenous women and the issues that they face as far as for example, the results and the recommendations of the missing and murdered Indigenous women and girls. There's a plethora of activity going on out there that we need to draw upon and be engaged in well beyond just those Indigenous specific instruments. I think that Walter's comment about outreach to civil society, I think this is one area that is needed, especially where, and he made the comment about the political arenas being polarized. I think this is absolutely true. We have a situation in Alaska where, I'll be frank, it's a Republican state. It always has been. It probably always will be, likely because of the discovery of oil on our land. And it's not just the political parties, but also there's an urban-rural divide. There are a lot of very complex issues that go into this. So outreach to civil society and educating them. And that was the other comment that he made is human rights education. I think it was Erica Diaz, one of the most prominent persons in the context of the emergence of the UN Declaration on the Rights of Indigenous Peoples, who stated that everyone needs human rights education. And I think Walter is right that our tribal leaders, our tribal councils, everyone needs human rights education. And I think I've run into situations, certainly at home in terms of our political leaders who believe that because they have been elected to those positions that they got it. They got it all figured out and handled. Well, I think human rights and the emerging jurisprudence is changing from day to day, and new developments take place. And I just think everyone needs human rights education. There's no question he's accurate about the issue of reform and the need for reform. And in so doing, I think we also, he raised a couple of different issues in the context of reform. And I think we need to be mindful of the fact that the social ills that he talked about, the cultural issues that he talked about, that they are all interrelated, interdependent, and indivisible. And so for us as Indigenous peoples, we have to kind of take an approach that points out exactly how when one particular element of the exercise and enjoyment of our human rights is denied either in a gross fashion or otherwise, that it affects all other activities going on within our communities. And so it's just the orientation of how these items are moved forward. I do think that a multi-pronged approach to all of this within the United States in terms of litigation, legislation, policy reform, the outreach to the media, the human rights education, et cetera, and also use of the international recourse mechanisms by our tribal governments and our tribal councils, our traditional councils. So a very multi-pronged approach and strategies at the local, regional, national, and international levels needs to be undertaken. I want to just say a few words about the promise of the Declaration. And really, for all intents and purposes, the promise of the Declaration can be found in the very final paragraph of the UN Declaration on the Rights of Indigenous Peoples, that we seek justice, democracy, respect for human rights, equality, especially in the context of our right to self-determination. Also, non-discrimination, good governance, and good faith. These are all the things that we sought in the whole exercise of achieving the human rights that are affirmed in the UN Declaration. So our basic dignity, our security, and our well-being are bound up in all of these different provisions. So I think it's important to remember also that our historical antecedents really do derive from our international relations with the colonizers, and that this is really the source, and we're seeking to go back to that particular source in terms of the objectives of the Declaration as Indigenous individuals, but also as Indigenous peoples, our collectivities. I want to say that we have to as well be mindful of the challenges that the Declaration itself faces. And many of you that have been working in this field know, and Jim discussed this in one of his reports as the Special Rapporteur on the Rights of Indigenous Peoples, the challenges to just the status of the Declaration. We're getting that everywhere, and I think that Indigenous peoples from the United States can play a significant role in countering these erroneous interpretations about the status of the Declaration. We have this emerging area of non-recognition of Indigenous peoples. We too can make a contribution with the solid foundation of the recognition of the sovereignty and the status of tribal governments across the United States to the larger international discussion of non-recognition of Indigenous peoples. The unfortunate reinterpretation of provisions of the UN Declaration. These white papers can possibly make a significant contribution. I think that the other dimension, I've already said it, is the complementary and mutually reinforcing relationship between the ILO Convention, the American Declaration, and the UN Declaration on the Rights of Indigenous Peoples. We have to also think about how they are interrelated and highlight those standards that may in fact be an improvement upon the UN Declaration. As Jim stated in his introductory remarks, that though it's not entirely perfect, we refer to it as one of the most comprehensive human rights instruments that exist. There still are some shortcomings. So let's look at all the relevant international human rights instruments and highlight the highest standards possible. The only other thing I wanted to say is just to kind of bring it closer to home for my own people and the challenges in federal Indian law. Heather mentioned that I was elected as the international chair of the Inuit Circumpolar Council, whose membership is 165,000 Inuit in Chukotka, Alaska, Canada, and Greenland. Well, in the case of Alaska, and this is true, I think, for Indigenous peoples around the world, we are the most regulated peoples on Earth. I mean, if you go downtown Anchorage, Alaska to the federal building, probably 60 to 80% of the employees in that building are there because we exist as Indigenous peoples. just because we are Alaska Native, we have generated all these different jobs in order to control how we live day to day in a wide range of things. There are 230 or so tribes out of the 540 or so tribes throughout the United States in Alaska. So 230 are approximately active in Alaska, either IRA or traditional councils. And so we face a really uneven situation. We have, in large part because of the Venati decision specifically, this wedge between our people and their territory in Indian country. And it's created some real difficulties and real challenges. In addition, the diverse issues that face us, we're subjects and objects of international treaties and agreements, such as the International Whaling Commission, the Migratory Birds Treaty, a range of other international instruments. So not only do we have to deal with the federal government and federal regimes, federal legal regimes in all of these species-specific areas, which is its own problem, but we also have to be mindful of what's happening at the state of Alaska level that has a very warped view of the term equality. I think that I could go on and on about just the context of the people that I represent just in Alaska, which is only Southwest, Northwest, and the North Slope of Alaska. But the challenges in terms of federal Indian law in our context is compounded by really, to a large extent, the political and legal arena that we deal in, and that the promise of the UN Declaration on the Rights of Indigenous Peoples has begun to help inform all of these different areas. I'll finish with the fact that we're working on a very significant project in Alaska right now on food sovereignty and self-government, and the range of the spectrum, the range of issues where we find small communities who are wholly exercising and enjoying the right of self-determination in the context of, for example, the taking of the bowhead whale is extraordinary. But at the other end of the spectrum, the overregulation of the people who rely upon salmon as their keystone resource is, I mean, it's stunning what has to be dealt with just to achieve food sovereignty and self-government. So thank you for your interest in Kuyanami.
Yate. Hello, good morning. Shaya Trobahanchla, Ado look I Bashishin, Kia Ani Dashiche, Ado Tlazatlana Dashinala, Ado the Nebenalt Ke Yanishle, Le Nhoka the Yendene Ainshle. Good morning, everyone. My clans are Water Edge. I'm born for the Reed people. My maternal grandparents are the Tarween House, and my Nullies, my paternal grandparents, are the Mini Goats. I represent the Navajo Nation. I'm an elected official, elected by our Navajo people. If you're not aware of, excuse me, who we are as Navajo people, we occupy actually now all 4 states in Arizona, New Mexico, Utah, and now Colorado. And we have over 27,000 square miles on the Navajo Nation. We have 24 elected council delegates. I sit on the Budget and Finance Committee, Sexual Assault Prevention Subcommittee, an appointment by Governor Doug Ducey to sit on the Arizona Human Trafficking Council and Human Trafficking Council in Utah as well. So thank you for this opportunity, Kristen, right? For allowing me to be on this panel, even at the last minute. So I was planning on just sitting down there and listening to all the presentations. So I'm really excited to be here. And the Navajo Nation has elected me to represent the nation at the United Nations speaking on the United Nations Declaration on the Rights of Indigenous People. We have a stance. We've passed legislations supporting UNDRIP. We have our Navajo people all over the world, not just on the reservations, but outside our sacred mountains. They are all over the world in military and education, working all over the world. And we know that this would be a protection, an additional protection to our people. In this day and age, we know that there's an assault on Navajo people, on Indigenous people. There's an assault against our way of life, against our cultural teachings, our language, our land, and these historical traumas. I'm very thankful that we're here to talk about this, and we want to continue this work. We know it's really important. We have our children that are educating themselves, and all of you that are here for your support. I appreciate your presence here, to be present here with us. But with the Navajo Nation, we have our own system of government that predates contact. We have our way of life that cannot be changed. Let's say, for instance, I introduce my clans. So let's say a young person, if I were to get mad at my father, I cannot say, I'm going to divorce you. I'm going to do away with my clan. And even in the four direction, we use the four direction, the east, as an entrance. And those are the things that we cannot change. The sacred mountains, the water, everything that's in our peacemaking system. So that cannot be changed. It's natural. And that is our way of life. It's not really a religion. It's our way of life. And I think that UNDRIP recognizes our way of life. It recognizes and honors our language. It honors our territories, and that's something that we will continue to work on. So, Mr. James and I thank you for your work at the United Nations, for everything that you have done for all of us, not just Indigenous people, but as human, as five-finger people. So I appreciate your work, and everyone here for CU Boulder, thank you. There's many people that I would like to thank in this process. We have this wonderful, this is in the working, it's a white paper. Thank you, Carla Fredericks, for your work in this. We have given our baseline data to CU Boulder to collect data on human trafficking on the Navajo Nation. And this is another assault on our people, and sometimes it's actually within the nation. It's our own people that are assaulting our own people as well. So we recognize that, and we're looking at the laws, some of these federal laws that are challenges to us, the hindrance. But we have wonderful people like my colleague, Delegate Amber Crotty, who continues to work on missing and murdered Indigenous women and the LGBTQ community. And I know in the state of Utah and other states, we have passed legislation, Senate bills, protecting our women, our children, and a lot of the underserved, such as the LGBTQ community, that there's actually no laws on the Navajo Nation protecting them. And I think with this Declaration on the Rights of Indigenous People, we're learning a lot, and we're taking a lot of the information back to the Navajo Nation. And we will continue to speak on this issue. So we have been presenting to the Senate Committee on Indian Affairs as well. And I think that education is key. And that's been repeated here over and over. And even to this day, when we meet with state legislatures, senators, congressmen, congresswomen, they come to me and ask me, Delegate Brown, what is culturally appropriate? Even calling me, do I call you Navajo? Do I call you Native American Indian? Do I call you what is culturally appropriate and what's inappropriate. And that's my job, that's our job, to bring the knowledge and the education of who we are as Navajo people. And it's really important that when we travel, that we pray. So with the people that travel with me, I know that in this weather, flying out here, it was quite a challenge last night. I was stuck on the tarmac for about 2 hours. So thank you, Oprah, for and Toli for speaking to me. But I wanted to take this really brief time to say a prayer in the Nebazad for all of us, and for our staff who have traveled from the Navajo Nation and from all over the world. So let me take this time to say a prayer. Biyagi kwegi nahanita ado di kwegi University of Colorado huliagi eya hinane kwegi di yendene hast a1 kedonkel tahan no londo le ado kodo tingo tradin na dank kai bajini bekat nastin ado di chidenat abene bej ene da lenigi kodonkel tahan no londo le nelch edigini tahan no lon ado ki kedad no I kwegi hijo di bik ia dil kito kwegi hijo ohadil al khaishi nitzen lenigi Bechadit zito nachande de dolel, di kwegi anilch adonil, di kwegi behez ani, nle altscho. Den nen leni belash latzish lejin leni bandidilielto, di kwegi jon nachane de dolel, di dans ande not ani lenigi, nkinandish, de dol zelto beliada at ehdolel. Kodoye belk edenit in lidolel shitcha shidi in den kodo. Jon hasli. Hijonasli. Thank you for allowing me to say a prayer. Okay, I feel better now. But really, I wanted to read this from the Rights of an Indigenous People. Recognizing the urgent need to respect and promote the inherent rights of Indigenous peoples, which derive from their political, economic, and social structures, and from their cultures, spiritual traditions, histories, and philosophies, especially their rights to their lands, territories, and resources. And in that paragraph, that is something that we will strive for. I believe and I know that as an Indigenous people, we are the caretakers with all of you of Mother Earth, of the fresh water, of the mountains, all the natural elements. And we need to continue this work in protecting Mother Earth. We're all aware that, how much fresh water do we have left? We recognize that. So we'll continue to fight for Mother Earth. We'll continue to fight and to keep our language, because our language is healing. Our language will heal. Our language will bring our people back together, and it will bring everybody together. I think that the greatest harm as humans, as five-finger people, is if we go out into the world and tell people that my way of life is the only and true way to live. I think in order for us to truly come together as a human race, we need to acknowledge one another and the beautiful difference that we hold. Our languages are different, our ways of life. I'm learning a lot, and once we come together as humans and put our differences aside, and this is a huge piece, this United Nations Declaration on the Rights of Indigenous People. And for the Navajo Nation, we would like full implementation of this United Nations Declaration on the Rights of an Indigenous People, especially as it relates to the free, prior, and informed consent. So we don't want to be just a consultation. We want to sit at the table. We want to be heard. We want to speak for our people, because no one knows us except for us. We see what goes on on our reservations and to our people. Who better to speak for us than ourselves? And that's something that we would like to sit at the United Nations and collaborate. And We have a lot of wonderful ideas where we can share with the world. There's a lot of areas that I know that we hold very sacred that has not been shared with the rest of the world. But in a way, we want to share that. And how do we do that? And that's really to have a seat at the table. It's really to be heard and continue this work with the United Nations. Thank you.
Well, with any luck, you'll be able to hear me. I'm going to pace because I do my best thinking when I'm pacing, so hopefully the mic will come on. Hopefully you can just hear me. So my name is Matthew Fletcher. I'm a scholar, so I guess there's a bunch of things that scholars are supposed to do now going forward. I want to talk a little bit about my journey as an Indian person who became a lawyer, became a law teacher, and how that relates to this kind of work. It might start with a little bit of denigration of lawyers and law teaching, and I don't really want to get too much into that, or you take it too seriously. Law is all about hierarchy. And so many levels in our profession and in our law teaching, and I was taught this in law school, and I teach it now as a law teacher, but we learn about hierarchies. Courts have hierarchies. Judges have hierarchies. There are laws that have hierarchies. We pay attention to the U.S. Constitution because it is supposed to be the supreme law of the land. We pay less attention to lower-level court decisions or regulations promulgated, ordinances promulgated by tribal governments or local counties. There's a hierarchy to everything we do. The other part of law and law teaching that makes all of this very difficult is that lawyers are always looking for something concrete to make an argument towards. Let me give you an example of how we run into trouble with in litigation or in advocacy when Indian law, when we say things like tribal sovereignty. If you ask 100 Indians what tribal sovereignty means, they'll probably give you about 75 or 80 different definitions. It means a lot of different things. And for a lawyer, that's not particularly helpful. When you stand up in front of a court and say something like tribal sovereignty, they don't know what you mean. And so there's sort of a problem of certitude. There's a problem of the indefinability of law that comes forth when we talk about the United Nations Declaration or any kind of international law, both in terms of hierarchy, both in terms of legal determinacy, just the determinacy of law. Now, I also teach jurisprudence. And so when we talk about these notions, these concepts in the UN Declaration, where it came from and who it applies to, what it can be used for, I have as a scholar and a law teacher who teaches jurisprudence, I have a lot of an opportunity to think about how this is going to work. And I think we're really on a good road. And Walter is giving us a wonderful path, and I think there's a little bit more that we can add to thinking about how that path is we're well on our way in some contexts. So I think of how we began with John Echohawk talking about how this project of tribal sovereignty really is only, this modern project is only about 50 or 60 years old. It's really since the 60s and 70s. It's really since the formation of the Native American Rights Fund out of California Union Legal Services. People like John Echohawk and Walter Echohawk and David Getchis, Charles Wilkinson, all these people who started this project. And, you know, in 1960-something, whenever NARF was formed and began to bring these cases, there are a lot of times where you would, a lot of statements that come out of the cases, I'm sure during an argument, that would sound completely foreign to us. The work that they started then has absolutely dramatically shifted the understanding of Indian people and Indian law and policy in the United States to a pretty shocking extent. I think of, there's a case pending in the Fifth Circuit, an oral argument, and there's a line in that case that got a lot of enormous attention. I think it was the headline in the Indian Country Today description or the coverage of that case. It's the Indian Child Welfare Act case. The attorney for the state of Texas referenced the children that are at issue in that case as our children, meaning the Texas's children. And the most conservative judge on that panel interrupted the Attorney General to say, those aren't your children, those are the children of the Indian tribes. I can't imagine any judge in the United States, at the time that NARF was founded, saying something like that. I don't know how this case is going to come out, but there's been such an incredible, dramatic, cultural, political, legal, economic shift, a jurisprudential shift in the understanding in the United States of Indian people and Indian law. And that is an ongoing project, obviously, right? Obviously, it's an ongoing project. It will be going on it's been going on 7 generations before, it'll go on 7 generations after us. Now, I think about the United Nations declarations and how that can fit. It's where there's so many different places in federal Indian law and advocacy where we can incorporate it right now. And we're starting to do that just a little bit. It's only been around for, what, 12 years? And the Obama administration's acceptance of it is even fewer years than that. It is an absolute infant in terms of the law. And I look at the hierarchy of law that I've worked with over the last several years, and I look at how I've personally written tribal court opinions, and I look at the hierarchy of all of law, where those tribal court opinions fit. They don't fit very high at the top. And I also work along with Ms. Single over here, formerly Professor Single, former Judge Single, who works for the state of Michigan. We work together on a project called the Restatement Project, the Law of American Indians, and for the American Law Institute. And there are times when we're in those meetings where I personally am amazed at how serious people take the restatement. There's no governmental entity that promulgates any of the text of the restatement. But at the same time, it is taken incredibly seriously. It is cited, not our restatement personally, it's not done yet, but other restatement projects are recited by the federal courts all the time, and the state courts too. And I think of other things in law, in Indian law, that are really important. I think of the Cohen Handbook on Federal Indian Law, which is cited repeatedly on almost every single major case in Indian law that is decided. The Cohen Handbook is cited. Now we're looking at hierarchies of actual legal authorities. Things like the restatement and the Cohen Handbook on Federal Indian Law are really high up, relatively speaking, in the hierarchy of law. And there's really no reason over time that the Declaration can't fit within that hierarchy. In fact, blow way past both of those things, and properly so. But it is going to take time, and it is going to require an enormous amount of the infrastructure that Walter is talking about. I think there are a few places in law right now where something like the UN Declaration can be very effective. I imagine, this is not me advocating this, but I imagine that an Indian tribe going to a meeting would say, I shouldn't do this, would say the attorney for the governor of a given state, saying we would like the state or the governor to adopt a particular position favoring tribal interests. Here is a list of reasons why. Those attorneys might cite the treaty. Now, we all know about treaties. Treaties are very wonderful instruments, but they are very vague in general. They're almost crippled by legal indeterminacy sometimes. Also, it is a benefit that they are indeterminate. The tribe might cite to its own laws, to the state governor or the Department of Interior, or even judges. The attorney might cite to the United Nations Declaration and say, in the end, when it comes to Indian law, there is a past, and there's a present, and there's a future. I think the past, a lot of Supreme Court decisions, a lot of treaties, a lot of old statutes, go all the way back to the founding of the United States. There's the present. We're in the middle of a self-determination era. We're deep in the heart of a self-determination era. And there is a future. Pretty sure that the United Nations Declaration is part of the future. Now, you can always remind policymakers, judges, decision makers, which side of history they want to be on. As a law professor, anybody who's taken Indian law, we can see a lot of the backward sides of history. Nobody likes to, Justice Reed probably is not, and if the dude was still around, doesn't want to be known as that guy who ridiculed Indian people in 1955 Teton. Maybe he does, I don't know. If he does, screw that guy. But nobody looks back and says, Teton, what a progressive, should be a part of the canon of American law. Nobody, not a single person, even those who hate Indians don't go to Teton and say, boy, that was a perfectly reasoned decision. It's a joke. It's an obscenity is what it is. You want to be on, everybody, every policymaker wants to be on the right side of history. And the UN Declaration is absolutely, we'll see, is going to be on the right side of history. One of the things, the last thing I'll conclude with is this is not an easy project. I mentioned that case earlier, the Indian child welfare case. When we were briefing the case, for a moment in time, we thought, hey, why not drop some references to the United Nations Declaration in an amicus brief that I was helping to write. It's the word child, I just checked it. That's why I have this thing here. It appears 11 times in the United Nations Declaration. This is an absolutely critical part of literally the future and figuratively the future of indigenous peoples. Why not put something in? It's just an amicus brief. Hell, nobody's even going to read it. But it became a thing, and we decided not to do it. And there are strategic reasons not to do that. When you're in the heart of litigation, high-stakes litigation, you want to be very careful in the kind of message you want to send. The United Nations Declaration, at that point in time, in that point in history, we're not quite ready to use it for that particular purpose. But that doesn't mean we ignore it, obviously. And I foresee, you know, when you get to federal judges, especially the U.S. Supreme Court, there's a long history that it seems to be recognized as being a legitimate thing of having a crazy-ass crank on the Supreme Court who's always writing these solitary, single opinions that are absolutely nuts. And then by the end of that person's tenure on the court, those crazy opinions become the law. And I think of William Rehnquist, who was an associate judge, who wrote these, was notorious for writing crazy-ass, right-wing concurrences and dissents that nobody signed on to in the 1970s, became the chief judge, and was writing the same exact opinions for 5-4 majorities in the 80s and 90s. And now you have another crazy-ass crank on the Supreme Court, Justice Thomas, writing these solitary opinions. Nobody else on the court is touching them with a stick. And I don't think he's going to be the guy who's going to be lasting long enough to be the chief judge who will eventually write 5-4 opinions, adopting his nutty opinions. But there's no reason why in the next 10 years we can't have a crazy-ass crank on the Supreme Court who's on the left side, who writes things like the United Nations Declaration as a real thing in the hierarchy of laws. And then over time, you really will get, I think, that those opinions will become, over time, legitimized, will rise to the hierarchy of law. And I think that's a project I would love to see happen, and I think will happen, and to be a part of. So thank you very much.
Questions. Wanted to thank the panelists and Mr. Echohawk for their good words and instructive remarks. There will be a coffee break now, and the next panel will begin right at 10:15.
Being strategic.
Yeah.